The for sale sign appeared overnight, polished, reflective, hammered neatly into the soil at the boundary of my ranch. The phone number on it wasn't mine, and the asking price was one I'd never spoken aloud. Someone had listed my lakeside property without my consent, armed with forged papers and a counterfeit power of attorney. The culprit? A member of the community board. When I confronted her, she didn't apologize. She dialed the sheriff and accused me of harassment. That was the moment I stopped reacting and started investigating. Not her motives, but her deeds. Turns out the home she'd lived in for 15 years sat on a parcel that could only be reached through an easement running across the land I'd inherited and never relinquished. So I began to wonder, if someone tries to steal your ground with fraud, what happens when you legally control the only road to theirs? If you're watching this from property you rightfully own, hit like and subscribe, because this story is proof that recorded rights defeat assumptions every single time. Before the sign, before the deceit, life on the ranch moved in slow, steady rhythm. I'd inherited it 2 years earlier. 120 acres of sloping fields, a quiet lake, and a gravel road that not only served my land, but, thanks to a recorded 1980s easement, also provided access to 3 neighboring tracts. The document was explicit: access limited to residential use, maintenance shared, revocable with cause and written notice. I'd skimmed it once during probate, filed it away, and never thought about it again. I worked remotely, kept a few cattle more for pride than profit, and lived mostly in peace. The homeowners association was a formality. Dues paid yearly, meetings ignored, newsletters that arrived quarterly with uneven fonts and misspelled words. Among the board's listed names was Elaine, the secretary, longtime resident and owner of Lot 47, a narrow strip of land holding a prefab home, a tin-roof carport, and not a single direct route to the county road. Her only way in or out was the easement cutting across my acreage, a fact I'd noted during title review but hadn't thought much about beyond grading the road once a year and keeping it clear. Elaine had been there since the late 90s, long before my inheritance. We'd never been close, but we'd never had problems either. I'd see her twice a year at most, a wave from her car window, a polite nod outside the post office. No tension, no history. That changed the morning I opened my laptop to check market prices and found my ranch splashed across a real estate website, professionally staged photos I'd never authorized, a glowing description I hadn't written, and a contact number I didn't recognize. The asking price was fair, maybe even ambitious, which meant whoever was behind it had done research, just not the part about owning the property they were selling. I dialed the number. A cheerful voice answered. The agent confirmed the listing was live and cheerfully offered to arrange a showing. I asked who had authorized it. She said the seller of record, Elaine Porter, had signed the documents herself and provided a notarized power of attorney. I told her that was impossible. I was the deed holder, the legal owner, and I'd never given anyone power of attorney, certainly not her. The line went silent for a moment, then the voice returned, tight and uneasy. I'll have to call you back. I didn't wait for her to. I phoned the county sheriff's non-emergency line and reported that my property had been listed for sale using forged paperwork. The deputy who answered seemed doubtful at first. Fraudulent real estate listings weren't the kind of crime they saw often, but once I provided a copy of my deed, the forged power of attorney, faxed, over by the rattled agent, within the hour and a detailed timeline, the skepticism faded. A report was filed, a case number issued, and an investigator assigned. Within 24 hours, the listing was pulled offline. But by then, the mess had already spread. 3 prospective buyers had called me. Directly, one had even driven 2 hours to walk the edge of the lake and get a feel for the property. The realtor, embarrassed and fully cooperative, turned over everything she'd been given: the counterfeit power of attorney, a falsified ID bearing my name, and a note instructing her to market the ranch discreetly so the tenant wouldn't catch wind of the sale. That tenant was me. I retained a lawyer the same week. After reviewing the evidence, he confirmed it was outright fraud and suggested we pursue both criminal charges and a civil suit. Then he added something unexpected. Before you go after her, he said, see if she's got any leverage points, something that runs through you. I frowned. What do you mean? Does she rely on your land for anything? Power lines, water, maybe access? That's when I pulled out the old easement agreement and read it again. Not like a neighbor this time, but like counsel preparing a case. Elaine's lot had no direct connection to the county road. Her only entry and exit ran along my private drive, secured by a 1987 easement that could be revoked with cause after 90 days. Written notice. Fraud, my attorney said, tapping the clause, qualifies as cause. I didn't rush to act. I waited while the investigation unfolded. The detectives interviewed Elaine. She denied any intent to defraud, insisting she'd merely been helping me offload a forgotten property. I hadn't abandoned the property, and the so-called misunderstanding over the power of attorney was anything but. Forensic examination confirmed what I already suspected. The signature had been traced, line for line. Within weeks, formal charges were filed: forgery, fraud, and attempted theft by deception. Elaine retained counsel of her own, and the matter slipped into the slow gears of the legal system. While prosecutors built their case, I started digging deeper into her land records. County assessment valued her lot at $38,000. Title, Elaine Porter. Mortgage, none. Lines, 1, for unpaid HOA dues, ironic, considering she sat on the board meant to enforce them. Most telling of all, county GIS maps and deed references confirmed her parcel's total dependence on the 1987 access easement. Recorded by book and page, mine. 5 months after the fraudulent listing, Elaine's attorney contacted mine with a settlement proposal. She would withdraw any claim, reimburse my legal expenses for $1,200, and agree to a permanent injunction preventing her from ever acting as my representative again. In return, I'd promise not to pursue further civil damages, I countered. She'd accept all of those terms. Plus, I'd buy her lot at its assessed value of $38,000, and she'd vacate within 60 days. If she refused, I'd begin revocation of the easement that made her property reachable at all. She refused. I followed through, filing formal notice of revocation, citing fraud as cause, and serving the required 90-day written notice in accordance with the original agreement. Her lawyer immediately filed for an emergency injunction to stop it. The matter moved to civil court, a quiet hearing room, 1 judge, 2 attorneys, and a single question that hadn't been tested in 35 years. Could an easement with a revocable for cause clause actually be revoked? Her attorney argued my action was retaliatory and punitive, that cutting off access would effectively trap her on her land. My lawyer countered with precision. The document's language was explicit. Revocable with cause. Fraud, he argued, satisfied any reasonable definition of cause. I had complied fully with notice requirements, down to certified mail and proof of receipt. The judge turned to Elaine's counsel and asked the simplest question of the day. Does your client deny that she attempted to sell the plaintiff's property using forged documents? He hesitated. The criminal trial was still pending. Denial here would open contradictions in that case. So he shifted tactics, claiming the penalty was disproportionate. My attorney responded by citing the easements, exact wording, and a list of precedents where fraud directly tied to the subject property had met the threshold for revocation. The judge examined both filings, verified the 90-day timeline, and ruled from the bench. The revocation stood. Elaine had 90 days from the date of notice, already counting down, to find alternate access or vacate her land. The judge acknowledged that the outcome was severe, but emphasized that the easement's language left no room for interpretation, and that Elaine's own conduct had triggered the clause designed to prevent exactly this kind of abuse. Elaine's complexion drained to white. Her lawyer immediately requested a stay of enforcement. The judge refused. The order stood as issued. 2 weeks later, Elaine tried to sell her lot. Without an access easement, it was just a fenced patch of dirt with no legal road in or out. Buyers vanished. The asking price tumbled twice. After 60 days, I stepped in with an offer, $38,000. The assessed value, as is, with explicit notice that the easement would not be reinstated. She accepted. The sale closed a month later. I became the owner of the landlocked parcel that had caused half a year of chaos, and the now defunct easement that once bound it to mine. I didn't keep it. 6 months after closing, I sold the lot to a neighbor who planned to merge it with an adjoining property that already had road access. I broke even after attorney fees, but profit was never the point. The point was accountability, that deceit carries weight, and written property rights outlast assumptions, entitlement, and even criminal defense strategies. Elaine eventually pled guilty to a lesser count, filing a false instrument. Her sentence, probation, restitution covering my legal costs, and a permanent mark on her record. She moved away not long after. The HOA board quietly filled her seat and avoided mentioning her name in future meetings. The neighborhood absorbed the lesson in silence. Access granted is not the same as access owned. For me, the ordeal wasn't a triumph so much as a hard-earned education in the fine print of property law. That easement had existed for decades, dormant, clear, and waiting to be honored or violated. Elaine chose the latter. I chose to enforce it. The price was real. $4,200 in fees, months of tension, and the loss of easy neighborly smiles. But the principle mattered more. You can't sell what you don't own, and you can't keep using land once you've defrauded the person who grants your right of passage. If you're sitting on land with old easements you've never read, or assuming that we've always done it this way equals legal authority, take this as your warning. Easements come with terms, and some include revocation clauses. Fraud is one of them. Would I do it again? I'm not sure. It was draining, costly, and awkward in a place where I still live. But one thing's certain. I read everything now. Every deed, every clause, every line that ties to my property. And if anyone ever tries to sell my land again, they'll run into the same binder that sat beside my desk for 5 months, stuffed with records, notices, and the patience to enforce every right written on paper. If this story made you rethink your own property files or gave you the resolve to say no to someone mistaking your land for theirs, don't just scroll past. Hit like so this warning reaches someone who needs to hear it. Share it with every property owner you know. Subscribe for the next story about boundaries, rights, and consequences. And tell me, have you ever had to defend a property line that others treated like a favor? Your story might be the one that helps someone draw theirs before it's too late.